The first thing, laws of, the Constitution of the United States and the laws of this state. And so the U.S. Constitution is always first. So, we take an oath to two constitutions. The federal authorities take it to one. But we talked about what the state may or may not do. Article 4, Section 4 it says the United States shall guarantee to every state in this union a republican form of government and shall protect each state of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. I've had some individuals tell me that they think that, okay, since the federal government is not making that guarantee of security, that the state should act in place of or supplant the federal government. The way I read that, there's kind of, I think to your frustration you mentioned a moment ago, there is nothing, and this is why I think the Supreme Court made that decision, there's nothing in there that says if the federal government's failing, then the state can supplant the federal government on federal responsibilities. The state may only do what is state law within those parameters, which I think is what we're doing with Operation Lone Star.
Right.
I wanted to get your
I think your assessment's right. There were some cases. There was a few cases back in the 90s where this invasion clause was tested out. There's not a lot of information on it, but there's clearly an invasion. But is there an invasion that connects to the Constitution in a way that the states can do something about it? That's a difficult question, and I think if you look at the case law, it looks like it would be in a situation where you have a foreign entity, not like the cartels, but an actual sovereign nation, and there's not time for the federal government to act, and the state can step in and protect their borders from a sovereign entity. The issue of whether it could be like the cartels is, I think, far less certain. And I'd say the case law, some of it says it's a political question, and then others specifically say, I think there was one case that specifically said that would not be applicable to the invasion clause. So I don't know, Ben, did I get that right as far as summarizing what little case law we've been able to find?
Yes, sir, I think that's right. To add just a little bit of color, various states brought lawsuits under the invasion clause in the 90s, running from about 94, 95 to 97 when they were decided in the courts of appeals. And I'd be happy to provide citations if you'd like, but all of those cases were ultimately rejected by the courts of appeals. Mostly they were decided on political question grounds. That is to say,
meaning what?
Meaning that the cases were non-justiciable in federal court, because the question as to whether there was an invasion was committed to the political branches under the.
So it should have been Congress deciding, not the judiciary.
Congress or the president, yes.
Right. Because we talk about original intent. And I'm not trying to be terribly ethereal, but when we talk about original intent as a military professional, I think probably what the
that's you, not me.
Yes, sir, but in a retired crispy status. But I think the founders, given at the time of the writing of the Constitution, without the modern technologies today that space-based intelligence and the like, I think the founders probably intended for an invasion to mean infantry, cavalry, artillery, and logistical supply train formations, kind of like what Santa Anna did in 1836 when he crossed the Rio Grande. That's probably what they had in mind. I mean, it's why we had in the early days of the country, you had coastal artillery units, because you wouldn't know if anybody at sea was out there till they break the horizon line. But when you look at, we've had over 6 million people come into the country since January of 2021, just in volume and numbers alone, and that 6 million is across the entirety of the southern border. But we've had 6 million people. That's more people than many of our states have in them. And at that pace, I mean, that's already more than Harris County coming into the country. And so is an invasion based upon the mode, i.e. military, or is the invasion based on on population, kind of like the difference between the
Right.
Senate and the House. One's based on the U.S. House, and one's based on population, and one's based on sovereign entity. And then the cartels are not state actors. We learned that during the September 11th timeframe, not to invoke September 11th, but we started using the terms non-state actors, and the cartels are not a state actor. But they're clearly, I mean, the governor's declared them a terror organization. There's some questions I'll ask about that, what that means, but they're not a sovereign entity that's operating under the Geneva Convention,
Right.
in the sense of an invasion and going from a peacetime operation to a wartime operation. So that's the challenge.
Yeah, well, there's also another one, and it's one I've thought about a lot. If somehow this evasion clause could be implemented at a state level, I'm not sure how much difference it would make, because the real problem here is we've got a partnership that was established on day one of the Biden administration, where he signaled to the cartels by saying, we're not going to deport anyone. Hey, bring as many people here as you can, and we'll let them in. And that's effectively what happened. And so that's why the numbers of, the human trafficking numbers are at $13 billion a year as far as profits, because they don't. In the past, Border Patrol has been able to stop a lot of the illegal immigration, and under the Trump administration, you can see the numbers were way down because they were actually returning people. In this case, the cartels are bringing them to Border Patrol. They're not hiding. I mean, this isn't like they're hiding. Most of them are not hiding. They're being directed to come to Border Patrol, and Border Patrol they're more of a logistics group, not a security group, and they are processing people. And so even if you had some ability to call up the National Guard, which I don't think would probably work because the president would immediately nationalize them, I don't know how you stop the real problem here, which is the participation, the partnership between the Biden administration and the cartels. And that's where most people come. They claim asylum. It's the magic word. It's the password, asylum. And the way that was handled in the Trump administration was, under federal law, it says if somebody is claiming asylum, they either have to be detained before their hearing, or they have to remain in the country they would pass through. They can't come in until their hearing. The Biden administration, this is what our lawsuit is about, is not doing it that way. They're not following that particular law. They're just transporting them all over the country, and then we lose track of them. So even if you declare an invasion, I don't know how you would stop the federal government, because that's really where the partnership is.
Well, in Article 1, Section 8, Clause 10, that's the one that talks about invasion, and it's the no state shall, without the consent of Congress, and that's the fulcrum between state operation and federal operation. Lay any duty of tonnage, keep troops or ships of war in time of peace, or enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. It is silent on who gets to decide the invasion. Is that the question? Because the governor's declared one. I think it's completely legitimate and worthy of such a declaration.
Yeah.
But based on what I think you said a moment ago, and the case law that you talked about in the 90s, does the governor? It would seem to me that the governor gets to decide that from an implied perspective from the Constitution. But I think what you were saying that that is unknown at this point. It would have to go to court to determine whether the state gets to decide it's been invaded.
I don't think there's been. Tell me if I'm wrong. I don't think there's any case law that has ever looked at that issue, unless I'm.
To the best of my knowledge, that's correct. When in the 90s, when invasion clause issues were raised, those were basically states going to federal court, and the states would say, we have been invaded and should be either recompensed or should have additional authorities. And as we discussed before, courts basically said those questions are non-justiciable. I am not aware of a federal court that has passed on, something along the lines of, the state has hereby declared an invasion and will be taking the following actions.
Right.
Yeah, so presumably, at this point, the governor could and has declared an invasion. I don't think that's been challenged as far as I know. Is that
Right.
true?
But see,
Not to my knowledge.
Yeah.
I would think that if it may not be justiciable, but I believe the governor has that authority intimated implied in the section of the Constitution. Because there's no state shall without the consent of Congress, and then you go through that list and it says, unless actually invaded or in such imminent danger as will not admit of delay. And it also says we can't enter into a compact with another state unless invaded or of such imminent danger you cannot admit of delay. Because of the nature of the circumstance, the way that reads to me is, we have specified and implied tasks. The specified task is you can't do it without Congress's permission unless you've been invaded or that you're in such imminent danger as you will not delay. 100,000 people dying of fentanyl every year, that's how many September 11ths?
It's a lot. Like 20.
In 4 years will surpass the number of casualties in World War II. That's what you're talking about here. But so I think it implies the governor has that authority to do so. The challenge, I think, is let me extrapolate a little further, if I may.
Sure.
In making the invasion declaration, it now means that, based upon this reads, you may not enter any agreement or compact with another state or a foreign power or engage in war unless actually invaded. The governor's declared an invasion. That means we can enter into a compact with other states. But the way this reads to me is that unless the other state we might compact with also declares the invasion, let's just pick next door to the governor of New Mexico. If New Mexico doesn't declare an invasion, the way this reads, they're still under the permission of Congress because they haven't declared an invasion. Am I reading that correctly?
I think you're right, but this is part of the frustration we're dealing with every day and what you're dealing with. We're in a place we've never been before. We have more illegal immigration and more ignoring of federal law than we've ever had as it relates to immigration. And so we're in uncharted territory as far as knowing what states can do because states have never had to wonder or really test this. So I think part of this is going to be we're going to have to figure out where are the areas we want to test. And that's part of why I've been saying for 2 years we should test US v. Arizona. We should test to see if the states can protect themselves given the circumstances that we're in that are so different than anything we've ever been in before, and because of what you just talked about, just the fentanyl crisis alone is worth considering, especially if you're like me and kids who have died, young kids who have died who had no idea they were taking fentanyl. So it's a horrible problem that we're dealing with that we've never had to deal with to this level. So I don't know, Ben, if you have anything to add to what I just said, but I think part of it is we just don't know until we get to court and test it. I do think there are things we can do to try to keep it more likely than not that we're going to win or that we have a better chance of winning. And I think that's some of the things we've thought about, how we could make some changes. We could suggest some things that would allow us a better chance of winning versus losing.
Okay.
Wouldn't guarantee it because we don't know.
Yeah.
I think that's right. I think the reading of the plain text that you're discussing sounds right to me. But it's certainly true that this is uncharted territory.
Yeah. Would such a compact have to be with another border state? It's not exactly germane, but in my Natural Resources Committee, we have a compact with the state of Vermont. Now, we had to get permission from Congress because it has to do with the low-level radioactive facility waste. But the states aren't contiguous. Would the states have to be contiguous here?
So I don't think so, only because I've been saying this, we're all border states now. Because of the transportation, the administration is flying people all over the country. They're not even asking permission. They're just dropping them off. I've talked to, just in Texas, talked to our police officers in Dallas who are telling me that, buses come in, people get off, they disappear into the night. They drop them off in the night. And that's happening all over the country. They're just being flown in and dropped off and they disappear. So I think there's a pretty strong argument that they don't have to be contiguous or next to the border, because while Texas is more affected than any other state and border states are more affected than other states, it is true that the Biden administration is moving people around, and it's affecting largely every state.
You mentioned asylum earlier. My understanding of asylum was that it was always, and this is a federal question, but I want to get yours, but asylum was always a question of, I think based upon UN protocol, asylum was always requested in the neighboring country, not I live halfway around the world and I'm going to get to Mexico as quickly as I can and request asylum that way. Or, if I've been to El Salvador and Nicaragua, and that asylum was in the next neighboring country based upon UN protocol, not this is the country I want to go be in, therefore I'm going to go claim asylum there. Can you expand on the understanding of asylum, that particularly because it's become the password?
Yeah, I don't know that answer, but I do know this, that in the past, about 14% of those seeking asylum got it. 12 to 14%. It was based on political persecution or religious persecution. So most people that went through the process were not found to actually be deserving of asylum, and they were sent back. Now, they just say it. These hearings, they don't happen for 2 or 3 years at best. People don't usually show up to them. And so it is a password. The idea of actually following some law on what asylum actually means, whether it's international law or whether it's federal law, it's kind of a joke. I mean, it's not really real, because most people are not showing up for their asylum hearings, and they're so backed up because there's too many people. Do you know about whether the contiguous country thing is applicable in the actual question of whether you can qualify for asylum?
I can add some color to that. I'm certainly aware that in the past, the United States has imposed, has reached safe third country agreements, things like that, with countries that people transit through, that require I believe, that require them to apply for asylum, individuals who wish to apply for asylum there. I'm generally given to understand that you're correct as to the treaties, but I do not think it is an out-and-out requirement of federal law that you apply in sort of the first country you transit through, a neighboring country. That said, much of the asylum system from a federal level is based on executive discretion, and so there are various things that previous administrations have required, like remain in Mexico or like applying for asylum in a safe third country, that my understanding is, as a general principle, the Biden administration is not doing.
And by the way, we know what works. We saw it in the Trump administration, that the Remain in Mexico program, tied with Title 42, tied with stopping catch and release, and tied with building a wall, the numbers of illegals dropped significantly under the Trump administration. And then within a year, I think under the Biden administration, when they sought to eliminate all the things that were working, the numbers increased to, I think it was a 300% increase in 1 year, and those numbers continue to go up. So we know what works, and I'm pretty certain that the Biden administration knows what works, and that's not what this seems to be about.
Yeah. Let me ask one more question, then I want to get to the members of the committee. If we successfully test with this legislative session, put something in law that would successfully test the courts, Article 3, Section 1 of the that's the Article 3 is the section that created the Supreme Court, and then for the Congress to create lesser courts. And I won't pull it up and read off my Constitution app, but it's the one that says that the Supreme Court shall have original jurisdiction where, in cases that involve a state, does the state have the ability to pursue the federal government? Is this when you say you want to test this, or does the federal government have to sue us? And because what I'm looking for is the time frame of getting from district court, Fifth Court of Appeals in New Orleans, and then the Supreme Court taking the case. what, 4 years, 5 years?
No, it could be, but it could be less.
Could be less. And I'm
it's-
just wondering how long the state can,
So
wait. I mean, that's the
provision
challenge.
you're
It's-
talking about, we sue other states. We're required by the Constitution to sue them at the U.S. Supreme Court. So when we sued, some of these, Georgia or whatever, New Mexico, we have to go directly to the Supreme Court. We've done that often. When we sue the federal government, we typically start it in district court.
Okay.
In this case, if you pass something like this, we wouldn't be the ones suing. They would sue us, trying to get some type of injunction to stop us from enforcing state law. And then we would step in and say, no, we have a right to do this. And then the game would be on. It would depend on, where they sued us. I can't predict where they would sue us, likely somewhere in Texas. And I can't predict what judge we'd be in front of. So,
But from a time frame, perspective, short of presidential elections that have to go to the Supreme Court, like
Yeah.
in 2000 or short of something like that, I assume we're talking a 2 to 3 year.
it's probably right, but that doesn't mean the law won't be in effect. They have to. It's a pretty high standard to get an injunction. You have to show irreparable harm, that you're likely to win on the merits, and let's say they pick a court that's, maybe not favorable to us. We lose. We're going to appeal that directly to the Fifth Circuit. Then they're going to appeal that directly to the U.S. Supreme Court. So it's going to go. That part of it's going to happen relatively quickly. So if we're successful, if the Supreme Court or the Fifth Circuit rule in our favor, then that law stays in place until we go through that long process of going from district court trial to appeal to potentially U.S. Supreme Court.
But the way Article 3, Section 1 reads is that it says if a state is a party, it's really state against state, not
That's
the
correct.
state's a party against the federal government.
Yes.
It has to go through the
Yes.
normal, rather than an immediate original jurisdiction.
Yeah,
of the
we have
Supreme Court.
52 of those going on right now, going through that process. We also have several state against state. Those went directly